Good morning, Philippines. Good morning, Cebu City. This is your host, Kimberly Cabantug. In today's Carolinian Law News, we will discuss issues on human rights, individual rights, and the fundamental powers of the state. For the headlines, a group of 20 people were arrested in Barangay Labangon, Cebu City by the police officers while conducting worship inside a house even under enhanced community quarantine. To give us the background story, let us hear the police report and recording.
20 people have gathered inside the house of one Apo Jose, alleging to be members of the servants of the Most High. They were conducting worship, dancing, and singing inside the house without wearing masks. We entered the house and warned them that they were violating the enhanced community quarantine imposed by the local government. They continued the worship despite our warnings. We then arrested them for desisting.
Now, for more details, let us also listen from the recorded statement of the congregation representative.
One afternoon, me and other members of Servants of the Most High gathered in the house of our church leader to do our prayer service and worship. While we were worshiping, the officers suddenly barged into Apo Jose's home unwelcome and told us to stop our prayer service and worship. As far as we are concerned, we were not doing something immoral. We were just peacefully doing our prayer service inside the house of our church leader. And besides, we are not that many and we did not even conduct our prayer service in a public place. We did not interrupt nor cause an inconvenience to other people.
Now that we have heard the facts of the case and the arguments from both parties, we have invited prominent lawyers to discuss to us the issues of the case. Our first guest is the defense counsel for the congregation, Attorney Norris Magallano. Good morning, Attorney.
Good morning, Ms. Cabantug.
Our second guest is from the Office of the City Prosecutor, Prosecutor Mary Carmille Daulo. Good morning, Prosecutor.
Good morning, Kim.
Thank you to the both of you for allotting your time.
It is my pleasure to shed light on the instant case.
As state's representative, it is my honor to air the side of the state on such important issues.
This segment will be a question and answer portion in relation to law in order to shed light on the present case. We have our audience to ask questions about the case. May we call on Ms. Shiurabelle?
Good morning, Prosecutor Daulo. I am Shiurabelle, a resident of Cebu City. My question is that, if you were the prosecutor handling the case, what charges will you file against the congregation and why?
Good morning, Shiurabelle. That's a good opening question. If I were the prosecutor of the case before us, the charges that I will file against the congregation are first, violation of EO 64, and second, violation of EO 66, both issued by Cebu City Mayor Edgar Labella, and in relation to Article 151 of the Revised Penal Code. Let's discuss them one by one. Why violation of EO number 64? Note that EO number 64 is an order issued declaring the city of Cebu under a state of enhanced community quarantine effective 12 noon of March 28, 2020 until present. Pursuant to the said declaration, all residents of Cebu City are directed to abide strictly to a number of policies and guidelines. One of these policies and guidelines is the mandatory stay-at-home order. It states here that all persons in Cebu City during the effectivity of the ECQ shall stay at home, and movement outside their home shall only be allowed for purposes of accessing basic necessities, given that only one member of the household is allowed to go out for this purpose. In the case before us, the congregation appears to have violated EO number 64 because they held a mass gathering in the house of their church leader instead of staying at their respective homes. This movement that they did outside their homes was not for the purpose of accessing basic necessities, which is the only movement allowed by the order. Furthermore, the members of the congregation are not included among those who are exempted by the mandatory stay-at-home order. Thus, they are required to comply.
Isn't staying in their church leader's home considered as staying at home, prosecutor?
We cannot accept the argument that the gathering is not contrary to the said order just because it was conducted inside someone else's house. In its literal sense, the order mandates that all persons in Cebu City shall stay in their own respective homes and not in anyone else's. Permitting staying in anyone else's homes would defeat the purpose of placing Cebu City under the ECQ, which is to avoid the transmission of the COVID-19. Imagine a group of 20 people cramped inside a house. This will definitely not mitigate the spread of the virus but will further aggravate it.
I agree, prosecutor. But how about EO number 66?
EO 66, on the other hand, is also easy to understand. It is an order requiring the wearing of face masks by all persons in public places within the territorial jurisdiction of Cebu City. Here, we will emphasize the term public places. As defined by the order, public places are all places that are accessible or open to the public or places for collective use, regardless of ownership or right to access. It also includes outdoor spaces where facilities are available for the public or where a crowd of people may gather. Clearly, EO number 66 was violated because the members of the congregation failed to wear masks in a public place.
But prosecutor, the members of the congregation did not exhibit any flu-like symptoms. So did they really have to wear a mask even if they were inside the church leader's house?
Of course, I maintain that the house of the church leader, which was the venue of the mass gathering, is within the contemplation of the term public place in section 1B of EO number 66. This is because it still served as a place for collective use to the church members where they can assemble as a congregation. They need not exhibit any symptoms for them to be required to comply. Provided the number of people cramped inside the house, social distancing is most likely not observed. Thus, the wearing of masks is crucial to protect them against the possible infection from COVID-19. Remember, as always, prevention is better than cure. Now, however, EOs number 64 and 66 do not have a penal clause, nor they expressly state any punishments for an offender's disobedience and non-compliance. So, we will charge them for violation of these ordinances in relation to Article 151 of the Revised Penal Code. Article 151 of the RPC penalizes resistance and disobedience to a person in authority or the agents of such person. Any person who shall resist or seriously disobey any person in authority will have a penalty of take note, arresto mayor, and a fine not exceeding 500 pesos. Since the police officers in the case before us were directed by the mayor to enforce EO number 64 and 66, disobedience to their warning is punishable by this article. The congregation turned a deaf ear and completely ignored the warning of the police officers, which clearly constitutes disobedience to persons in authority. Therefore, the arrest of the whole congregation was valid, and the charges of violation of EO 64 and 66 in relation to 151 of RPC may be filed against them.
Thank you, prosecutor.
Thank you as well, Ms. Shiurabelle.
Now, for the question for the defense, let us hear our next viewer, Ms. Kryzza Calo.
Good morning, Attorney Magallano. I am Kryzza Marie Calo, a student of the University of San Carlos. My question is there any violation committed by the arresting officers?
So good morning, Kryzza. So based on the testimonies given earlier, the arresting officers could be held liable for violating Articles 128 and 132 of the Revised Penal Code. Let's elaborate. First, Article 128 of the Revised Penal Code penalizes public officers or employees who are not authorized by a judicial order for violating the domicile of individuals. For each man's home is his castle, and it is his safest refuge. One of the acts punishable under the said provision is entering any dwelling against the will of the owner. The opposition, in this case, can either be expressed or implied. Here in this case, officers are public officers. They barge into the house of Apo Jose against his will. It can be gleaned from the facts that there was an implied prohibition on the part of Apo Jose and the members against the presence of the police officers. For the purpose of their gathering was for the worship of their church. And only those who are members are allowed inside. Since the police officers are not members of the church, there is an implied prohibition against their presence. Moreover, the police officers are not authorized by a judicial order since they do not have a search warrant. Thus, their act of barging and entering the house of Apo Jose against his will is a violation under Article 128 of the Revised Penal Code. Second, under Article 132 of the Revised Penal Code, it penalizes public officers or employees who prevent or disturb the ceremonies or manifestations or worship of any religion. In the case of U.S. v. Valcorta, the Supreme Court, citing Hull v. State, held that the reading of some verses out of a Bible in a private house by a group of 10 to 20 persons is a religious service. The reason for this ruling is that there is no provision of law which requires religious service to be conducted in an approved orthodox style in order to merit against interference and disturbance. Based from the facts of the case, the group members were singing, dancing, and worshiping, so clearly they were engaged in a religious worship. When they were suddenly interrupted by the police officers who suddenly barged inside the house. Through these acts, the officers evidently disturbed the ongoing religious ceremony happening inside the house of Apo Jose. So thus, it constitutes a violation under Article 132 of the Revised Penal Code.
If you were the defense counsel, how would you defend the members who have been arrested and charged?
Having no search warrant, the police officers violated the constitutional right of Apo Jose and the other members against unreasonable searches and seizures when the police officers barged suddenly into the dwelling of Apo Jose. Second, the arrest is an invalid exercise of police power since it is both oppressive and not necessary. Lastly, the warrantless arrest is unlawful because it did not fall under any of the circumstances set forth in Section 5, Rule 113 of the Revised Rules of Court. For my first point, the police officers violated the constitutional right of Apo Jose when they suddenly barged into the dwelling without a search warrant. In the instant case, the arresting officers, as established, suddenly barged inside the house and arrested the people without being authorized by a judicial order. In People v. Aruta, the court explained that searches and seizures are normally unreasonable unless they are authorized by a validly issued warrant or warrant of arrest. However, in People v. Cogaed, the court clarified that there are exceptional circumstances when searches and seizures are reasonable even when warrantless.
What are these instances contemplated, attorney?
So, the following are recognized instances of permissible warrantless searches laid down in jurisprudence. First, a warrantless search incidental to a lawful arrest. Second, search of evidence in plain view. Third, search of a moving vehicle. Fourth, consented warrantless searches. Fifth, custom search. Sixth, stop and frisk situations. And lastly, exigent and emergency situations searches.
Does the present case fall within the recognized exceptional circumstances, attorney?
The present case does not fall within the recognized exceptional circumstances. So evidently, the arresting officers violated the fundamental right of apose against unreasonable searches and seizures, which is guaranteed by no less than the 1987 Constitution itself. For my second point, the arrest is an invalid exercise of police power since it is both oppressive and not necessary.
Attorney, can you elaborate more on what exactly is this police power?
So, police power is defined as the power inherent in the state to regulate liberty and property for the promotion of general welfare. By reason of its function, it extends to the great public needs and is described as the most pervasive, the least limitable, and the most demanding of the three inherent powers of the state. In order to determine whether or not the exercise of police power is valid or invalid, requires the concurrence of the following requisites. So first, the subject matter of the law must be lawful. And second, the means employed to attain the purpose of the law must take note, be reasonably necessary, and not unduly oppressive upon individuals. So, in this case, it is not denied that the subject matter of the law, which is the promotion of public health and safety, is lawful. However, there's no concurrence of the requisites since the means employed by the police officers do not serve the purpose of the law. And moreover, it is not necessary and it is oppressive upon the individual.
Attorney, what is your take on the arrest of the 20 or so people during this time of public health emergency?
By arresting the defendants for what they did, the police officers are merely adding to the congestion of Philippine jails. During a public health emergency like COVID-19, prison cells are particularly because people are in close proximity to each other at all times. This greatly increases the chance of infection for both the defendants and the police officers. So thus, the act of arrest is unduly oppressive and not reasonable because it could cost the very lives, not only that of the defendants, but also the police officers themselves. In light of the public health emergency we are experiencing right now, congesting the jails and prisons would not serve the real purpose of the law.
Now, the ultimate question, attorney, was the warrantless arrest valid?
In my opinion, no, the warrantless arrest was not valid. Under Section 5 of Rule 113 of the Rules of Court, a lawful arrest may be effected by a peace officer or a private person even without a warrant of arrest in the following instances. So first, when, in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Second, during a hot pursuit or when a crime has just been committed and the police or law enforcement officer has probable cause to believe, based on personal knowledge, that one has committed such crime. And lastly, if one is a prisoner or person deprived of liberty who escaped prison. If these circumstances do not apply, a valid warrant of arrest is needed to apprehend a person. In this case, the apprehending officers claim that defendants were caught in flagrante delicto. However, let's look at the requirements of an in flagrante delicto arrest. So in order to warrant an in flagrante delicto arrest, the following requisites must concur. First, the person to be arrested must execute an overt act indicating that he has just committed, is actually committing, or is attempting to commit a crime. And second, such overt act is done in the presence or within the view of the arresting officer. Based on the given facts, it is doubtful that the police officers were able to witness any overt act done by the members before entering the private home of Apo Jose to validly effect an in flagrante delicto arrest. Because the police officers were outside the house. So how could they see what was happening inside? This made it harder to see for them to see the ongoings inside the house of Apo Jose. Moreover, singing and dancing are not sufficient indicators that a crime was being indicated since these are normal activities. It was only after the police, who were not armed with a search warrant, illegally entered the house that they supposedly saw the gathering of people. Furthermore, the police officers cannot arrest persons not wearing a face mask and not following social distancing rules since these acts are not included in the list of prohibited acts with punishment under RA 11469 or the Bayanihan to Heal as One Act and RA 11332 or the Mandatory Reporting of Notifiable Diseases Act. Thus, the warrantless arrest conducted by the police officers was unlawful since it failed to satisfy the requirements of the delicto arrest. Consequently, the police officers failed to acquire jurisdiction over the person of the accused. This is in line with the ruling of the Supreme Court in the case of Sapi v. People.
Thank you so much for answering my questions, attorney.
Thank you to Kryzza.
Thank you to Prosecutor Daulo and Attorney Magallano for the comprehensive discussion. To set as moderator and to give additional information, let us hear from the prominent retired RTC judge, Honorable Nieves Mercader, for her expert opinion. Good day, Judge!
Good morning. Hope all is well and everyone is safe.
Now, we have another question from our viewer.
I am Christine Mantuhac, a law student from University of San Carlos. My question is, if you were the judge handling the case, how will you resolve the case at hand? And what would be your judgment?
These are my opinions on an issue of great importance. First, under the Republic Act number 11469 or the Bayanihan to Heal as One Act, it listed there the offenses punishable with imprisonment or a fine or both at the discretion of the court. However, not staying at home, not wearing face mask, conducting mass gatherings such as prayer assembly, and not following social distancing rule are not included in the list of prohibited acts or acts with punishment. Therefore, in this instant case, members of the congregation cannot be held liable in violation of RA number 11469, for there is no basis for the arrest, especially when there is no warrant. Second point is, in cases when there is a city ordinance which prohibits the people to go out without face mask or quarantine pass, do mass gathering, social distancing is not observed, or curfew is violated, the ordinance must state explicitly that these acts are prohibited and there is punishment for disobeying the ordinance. No one should be punished unless in accordance with a law that is certain and unambiguous. Now, applying Executive Order number 64, which hereby placed the City of Cebu under enhanced community quarantine and mandates the stay-at-home order for all persons except for purposes of accessing basic necessities, EO 64 does not provide penalties for disobedience of the order. Hence, no person shall be arrested in violation of EO 64. Therefore, members of the congregation cannot be held criminally liable for disobeying the stay-at-home order when proceeding to the house of Apo Jose and do prayer assembly. We also have Executive Order number 66, requiring the wearing of masks by all persons in public places within the territorial jurisdiction of the City of Cebu. The penalty for those who violate shall be in accordance with the penalties under Section 10 of Republic Act number 11332 or the Mandatory Reporting of Notifiable Diseases and Health Events of Public Concern Act. We also have Executive Order numbers 52 and 52-A, which hereby canceled or postponed all mass gatherings such as religious worship, private or publicly led. However, the order fails to provide penalties for any violation thereof. In the case at bar, the house of Apo Jose is considered to be a public place used collectively by members of the congregation for their worship. Thus, the wearing of masks shall be done at all times inside the house of Apo Jose, where transmission of COVID-19 may take place. The church members failed to wear masks during their prayer assembly, hence considered to be a criminal act punishable under EO 66 in accordance with Section 10 of RA number 11332. Though the church members did prayer assembly, EO number 52 and 52-A do not provide penalties for disobeying mass gatherings. Therefore, members of the congregation are in violation of mandatory wearing of face mask but cannot be charged in violation of mass gathering. My third point is with regards to Article 151 of the Revised Penal Code. There is no question that the members of the congregation were in defiance of the order of the police officers. Oblivious of the warning, the congregation turned a deaf ear and completely ignored the police officers. Their subsequent actions after the warning established disobedience to the police officers who are in the discharge of their official duties. Therefore, the members of the congregation are guilty or in violation of Article 151 of the RPC. Now to my last point is under the Rules of Court, Rule 113, Section 5. A warrantless arrest is lawful under three circumstances. First is when, in the presence of the police officer, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. This is what we call in flagrante delicto arrest. Second circumstance is when an offense has just been committed and he has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. This is also known as the hot pursuit arrest. And last, when the person to be arrested is a prisoner who has escaped from a penal establishment. Applying the facts of the case, this instant case is a case of a hot pursuit. The police officers have personal knowledge of the movement of what was happening inside the house of the church leader. It would be impossible to believe that the acts of singing, dancing, and worshiping cannot be heard outside the house of Apo Jose, considering the number of people who participated in the prayer assembly. Such acts constitute probable cause to believe on the part of the arresting officer that an offense has just been committed. In fact, upon barging the house of Apo Jose, the police officers caught the church members not wearing masks, which is punishable under EO number 66, while doing the prayer assembly, plus the failure to observe social distancing rule. Therefore, a valid warrantless arrest was effected by the police officers in accordance with Rule 113, Section 5B of the Rules of Court. To sum it up, based on my opinion and experience, the warrantless arrest of the members of the congregation is lawful, for they are guilty or in violation of EO number 66, which is the mandatory wearing of masks in public places, and Article 151 of the Revised Penal Code, which is the resistance and disobedience to a person in authority, and they should hereby be penalized accordingly.
Thank you for your discussion, Judge. What would you like to tell to our viewers?
In implementing policies and actions in support of the enhanced community quarantine, government officials must always be conscious of not violating any rights. The protection of our human rights is the very reason why we fight COVID-19.
And those were the latest updates for today. For the Carolinian Law News, this is your host, Kimberly Cabantug. Stay home and stay safe. Let us use this time to reflect on what we can do to be better individuals. Philippines, Cebu City, good morning.